Hi everyone, let's talk about intentional torts and negligence. In this lesson we'll list and describe some common intentional torts, we'll define negligence and examine the elements necessary to prove it, and we'll examine some common defenses to a negligence claim. You may have never heard the word tort before, but it's a legal term that means a civil wrong that causes injury or harm. Torts can be intentional or unintentional. We call unintentional torts negligence most of the time. The injured party can bring a civil lawsuit to seek compensation for a wrong done to the party or to the party's property. Some wrongs can give rise to both tort claims and criminal charges. So an example would be if somebody assaults somebody else. They could be liable for money damages in a civil suit, as well as possibly facing a criminal trial. Let's look at some intentional torts. This is a category of torts that requires the defendant possessed the intent to do the act that caused the injury. The first example here is assault, which is the threat of immediate harm or offensive contact. An action that arouses reasonable apprehension of imminent harm. So the strict definition of assault is that we don't actually have to have physical contact. Just the threat of harm is enough. Battery, according to its strict definition, is when somebody actually follows through with the threat and actually does physically contact somebody in a way that causes physical injury. There can be direct or indirect physical contact between the victim and the perpetrator. A lot of jurisdictions, and ours is included, in North Carolina, have shortened or have removed the strict definition or the clear delineation between assault and battery and just consider the one charge of assault, where it's either less serious if you don't actually injure them or it's more serious if you do actually injure them. So the line isn't always clear if you're going through the legal system, but according to the strict definitions, there's that separation there. The doctrine of transferred intent means that, let's say I set out to actually batter somebody. Let's say I'm going to throw a rock at somebody. But let's also assume that I missed the person that I meant to hit and I hit somebody else behind them. Even though I did not intend to harm that third person, the doctrine of transferred intent means that the law transfers my intent. I'm the perpetrator in this example. It transfers my intent from target to actual victim. So I could no longer claim that I'm not liable for battery because I didn't intend to harm them. False imprisonment is another intentional tort. It's the intentional confinement or restraint of another person without their authority or justification and without that person's consent by I can use physical force, I can use some kind of barrier, I can use a threat of physical harm, or false arrest. So things get a little bit unclear sometimes. So an example would be the merchant protection statutes. Oftentimes this is just called the shopkeeper's privilege. This means that a merchant may stop, detain, and investigate suspected shoplifters without being held liable for false imprisonment if there are reasonable grounds for suspicion, if the suspects are detained for only a reasonable amount of time, and if the investigations are conducted in a reasonable manner. Okay, so it's not always clear what's reasonable, and I have to be very careful if I'm a shopkeeper not to use an unreasonable amount of force or keep somebody for an unreasonable amount of time. Doing these things can lead to a charge of false imprisonment or maybe even battery. So this is why a lot of stores don't even bother trying to stop shoplifters physically. They might catch them on camera and then turn that over to the police and try to catch up with them later. But you open yourself up to at least a possibility of liability if you're actually physically stopping and detaining somebody who you suspect of shoplifting. An example that we have of that is Walmart stores versus Cockrell. And this is, I'll read an excerpt of this case for you so you can sort of get an idea of what was going on. So Carl Cockrell and his parents went to a store owned by Walmart stores. Cockrell stayed for about 5 minutes and decided to leave. As he was going out the front door, Raymond Navarro, a Walmart loss prevention officer, stopped him and requested that Cockrell follow him to the manager's office. Once in the office, Navarro told Cockrell to pull his pants down. Cockrell put his hands between his shorts and underwear, shook them, and nothing fell out. Next, Navarro told him to take off his shirt. Cockrell raised his shirt, revealing a large bandage that covered a surgical wound on the right side of his abdomen. Cockrell had recently had a liver transplant. Navarro asked him to take off the bandage, despite Cockrell's explanation that the bandage maintained a sterile environment around his surgical wound. On Navarro's insistence, Cockrell took down the bandage, revealing the wound. Navarro let Cockrell go. Cockrell sued Walmart to recover damages for false imprisonment. Walmart defended, alleging that the shopkeeper's privilege protected the store from liability. The trial court found in favor of Cockrell and awarded him $300,000 for his mental anguish. Walmart appealed. So, pretty extreme. I don't know if Navarro would have known that Cockrell actually had a liver transplant and there was a bandage covering an actual wound there, but it does seem pretty extreme. In court, they found that Navarro didn't really have a reasonable grounds to suspect that Cockrell had actually been shoplifting. Just, standing somewhere looking around doesn't necessarily mean that you're stealing. So they went too far, and then Walmart's on the hook for this $200,000 judgment. So it can get expensive pretty quickly if somebody steps too far, and that's why a lot of the stores just don't even bother anymore. Continuing on with intentional torts, we have the misappropriation of the right to publicity. A lot of times this is just called the tort of appropriation. This is an attempt by another person to appropriate a living person's name or identity for commercial purposes. The recourse a plaintiff would have is to recover the unauthorized profits made by the offender, or you can do both, obtain an injunction preventing further unauthorized use of his or her name or identity. So, everybody has the right to use their own image for commercial purposes. And if somebody else tries to use your image without your permission for commercial purposes, then that's appropriation. So I just got done watching this great documentary on ESPN about Michael Jordan and the Bulls back in the 90s. And, Michael Jordan's a very successful basketball player and very wealthy person. A lot of his personal wealth came from these endorsement deals, namely Nike. So what if I was to start up my own shoe company and I wanted it to be successful? I wanted to give the image of, top athletes using my brand. And let's just say I use a picture of Michael Jordan saying that he loves my shoes. Well, if I didn't get his permission, this is going to land me in a lot of trouble. He'll be able to sue me for whatever profits I made. He'll be able to obtain an injunction preventing me from using his name ever again. And there might be some additional charges in there as well. So that's why these deals can be so lucrative. You have to negotiate with the party, and if they're a superstar athlete, then it's going to be expensive. The invasion of the right to privacy. Okay. Interestingly enough, the U.S. Constitution doesn't actually spell out a right to privacy. We sort of cobble together a bunch of amendments and sort of piece together this right to privacy, and now it's just commonly understood that we have this right. But the basic idea is that it's a violation of a person's right to live his or her life without being subjected to unwanted and undesired publicity. So, examples, hacking into somebody else's email, disclosing private healthcare records, taking unwanted pictures in a locker room, all violate my right to privacy. Key in whether or not somebody has actually invaded my privacy, I have to analyze what kind of expectation to privacy do I have in some particular context. If I'm in my own home, that's probably the highest expectation of privacy a person can have. If I'm just out walking around a neighborhood or walking out in public, I have a very low expectation of privacy. If someone was to take my picture just walking down a street, I probably can't do anything to stop them because I'm out in public. However, if I catch somebody trying to take pictures inside of my own home, then there's a lot I can do to try to stop them. Placing a person in a false light also constitutes invasion of privacy. So an example could be somebody writing a very highly offensive letter, sending it out and signing my name, trying to make me look like the person who wrote these highly offensive things, thus painting me in this false light, would also be considered invasion of privacy. Continuing on with an intentional torts, defamation of character. This is a false statement or statements made by one person about another person. We divide this up into two categories: slander, which is oral defamation, and libel, which is defamation that has been put down in some kind of permanent medium, whether it be writing or video or audio. A plaintiff must prove, in order to prove defamation, I have to show that, one, the defendant made an untrue statement of fact about the plaintiff. Untrue being the key word here, because if what I'm saying is true, then it's not defamation, it's just me telling the truth. Two, the statement was intentionally or accidentally published to a third party. So if they're just saying false things to me and I'm the only one in the room and it's not being recorded, then it's not defamation, it's just somebody telling untrue things to me, to my face. But if they publish it to a third party and now other people think bad things about me and it's harmed my reputation, damaged my the way that people look at me in the community, then that would be defamation. A very famous case that happened a couple decades ago was Jerry Falwell versus Hustler magazine. Basically, the creator of the Hustler magazine thought he always had a personal beef with Jerry Falwell. They kind of had a rivalry going on. They didn't like each other very much. Jerry Falwell was a very popular televangelist at the time. So anyway, they ran a fake ad, sort of like a joke ad in Hustler magazine, saying some pretty defamatory things about Jerry Falwell. In Hustler's view, nobody would actually read this and think that they're actually true. It was just kind of a joke, poking fun at Falwell. Falwell, however, took great offense at it and sued Hustler magazine. So after a lot of back and forth, the long and short of it is that we had this parody ad in the magazine portraying Falwell talking about his, quote, first time with Campari. Falwell sues for defamation of character and intentional infliction of emotional distress. A lower court awards Falwell $200,000, and this gets appealed to the Supreme Court. What the Supreme Court found was that Falwell is a public figure. Now, what we didn't mention earlier is that the bar is a little bit higher for people who are public figures. So these are people who are very famous or in the media a lot. So political figures, famous actors, athletes, stuff like that can be considered public figures. And it raises the bar a little bit on defamation. We have to prove actual malice, meaning I definitely knew that thing was untrue and I said it anyway, trying to harm them. So anyway, the court found that Falwell is a public figure. The ad is not reasonably believable, and Hustler was therefore protected under the First Amendment. So, they had to sit down and try to think through the eyes of a reasonable person reading this ad. Would they think that the things that the ad is claiming, are those actually true? And the court decided that no, a reasonable person reading it would see it for what it was, which was a parody ad, and therefore Falwell shouldn't be able to sue. Disparagement is basically defamation, but rather than against a person, we're making false statements about a competitor's products, about their services, property, business. So I'm not defaming a person's reputation. I'm defaming a business's reputation. And we give that a special term, disparagement. Intentional misrepresentation, we also call fraud, and this is intentionally defrauding a person out of money, property, or something else of value. Intentional infliction of emotional distress. So this is causing someone extreme and outrageous, it's me displaying extreme and outrageous conduct that intentionally or recklessly causes severe emotional distress to another person, also called the tort of outrage. This is me saying something so extreme and outlandish that I know it's going to cause somebody extreme emotional distress. So calling up somebody and saying that a family member has died and then trying to pass that off as a prank, obviously that would cause somebody extreme emotional distress, and that's the kind of thing that can land me in some trouble. Malicious prosecution is if somebody sues me and I think they have absolutely no grounds for a lawsuit, and I think they're just trying to cost me time and money, and they're doing it purely out of malice with no real issue at play. I can file a countersuit saying that they're bringing the suit with malice and without probable cause for a lawsuit. So now we're going to switch gears. Those were the intentional torts that we're going to talk about. Now let's look at unintentional torts. And we usually just call these negligence. So rather than somebody intentionally seeking to harm somebody else, there may not be intent at all. It might just be that they either were or were not supposed to do something and it caused somebody harm. So it's the doctrine that says a person is liable for harm that is the foreseeable consequence of his or her actions, saying that negligence is an omission to do something which a reasonable person would do, or doing something which a prudent and reasonable person would not do. Now we're getting into the area where, a common example might be if we're walking around in a grocery store and somebody spills something. Now there's a wet spot on the floor. Okay, so the store has some obligation to, within a reasonable amount of time, as soon as they are aware of that wet spot, to go put up signs warning people that there's a slippery floor right here, maybe even putting up maybe a barrier, or just at least trying to clean it up as fast as they can to limit that dangerous condition. If they don't do that, then that can be considered negligent. So the elements of establishing negligence. One, I have to show that a defendant owed a duty of care to the plaintiff. Next, I have to show that the defendant breached that duty of care. Then I have to show that the plaintiff suffered an injury. And then finally, I have to show that the defendant's negligent act was the actual and proximate cause of the plaintiff's injury. We'll talk about each one of those a little bit more in depth. So first of all, we look at duty of care. This is the general obligation people owe each other to not cause any unreasonable harm or risk of harm. We can use a couple different tests to determine whether or not a duty of care was owed. One is the reasonable person standard. The next one is the reasonable professional standard. The reasonable person standard is when the court goes in and tries to reason or look at things through the eyes of a normal, reasonable person in society with at least some minimal amount of rational skills and intelligence. So what would a reasonable person have done in this situation? And if the business or the person didn't act as a reasonable person would, we oftentimes find liability. The reasonable professional standard would be applied if we're looking at a lawsuit that might involve maybe a doctor or a lawyer or somebody else who's considered to be a professional and has certain standards within their practice that we can apply. Rather than just a general reasonable person, what would the reasonable professional in that line of work have done? Breaching that duty of care is a failure to exercise care or to act as a reasonable person would act. So pretty straightforward. I owe that duty of care to people out in society. And if I fail to exercise care or I don't act as a reasonable person would, then I have breached that duty of care. Next, I have to show that injury actually happened. So this is pretty important. As part of the lawsuit, I'm going to have to show exactly what kind of injuries were suffered, whether it be personal, that I can show through medical records, whether it be financial, that I might be able to show with some financial records, or maybe even mental distress, which I can show through a psychological evaluation. So different ways to demonstrate these injuries. If no injuries are suffered, then I can't recover any damages. Even if a person breached a duty of care, if I didn't suffer any type of loss, then I don't have anything to sue for. The amount of damages recoverable are going to depend on the effect of the injury on the plaintiff's life or profession. An example case of negligence is Jones versus City of Seattle, Washington, which happened in 2013 in the state of Washington. This was a very unfortunate case of a firefighter at the fire station. The firefighter slept on the second floor, and all the equipment was on the first floor. And as is, or at least was common in fire stations, there was a fire pole where the firefighters could slide quickly from one floor to the next. There was 15 feet between the first and second floors. So the hole for the pole was next to the bathroom, or at least close to the bathroom. And then one night, while Jones got up in the middle of the night to use the bathroom, he accidentally fell through that hole, falling 15 feet to the floor beneath. He suffered permanent physical and cognitive disability as a result. At trial, he was awarded $12.75 million as a judgment because he was going to require lifelong care. At issue was whether or not the city of Seattle had a duty to provide more protection, or at least try to mitigate the danger in that fire station as a result of that pole hole. After a long trial and a lot of back and forth, the court ultimately reached the conclusion that the city should have done more to try to protect the firefighters, or try to reduce the risk that somebody would actually fall through this. And so the judgment was upheld. They found the city negligent and liable for those damages. Bringing things a little bit closer to home, there was a case in 2012, Bryson versus Coastal Plain League. This happened out at a Gastonia Grizzlies game, where the plaintiff Bryson was attending a baseball game. He sat down the third base line by the bullpen where the opposing team's pitchers were warming up. Depending on whose version of the story you listen to, he was either sitting a reasonable distance away from the fence or hanging over the fence talking to the opposing pitchers. Either way, he was struck by a wild pitch, causing significant injury to his face and head region. Bryson sued the Grizzlies and the city for negligence. His wife later added a claim for loss of consortium, which is a separate tort that we won't get into much here, but it's sort of an interesting one. The lower court grants summary judgment for the Coastal Plain League, which is that's the league that the Grizzlies play for, and then the plaintiff appeals. Later on in the appellate court, it says that the duty to exercise reasonable care is fulfilled by providing a screened area for participants to sit in. The plaintiff chose to sit outside that area, and the possibility of a wild pitch or foul ball is an open and obvious danger. So the courts are aware of the fact that if you go to a baseball game, most reasonable people are aware of the possibility of a fly ball or a wild pitch going up into the stands. And as long as the team provided a screened area as an option for people to sit in, then it had fulfilled its duty of trying to, it's fulfilled its duty of care to the spectators, and thus it was not liable for this very unfortunate incident. The next element is causation. So there are two levels here. One is actual cause, and one is proximate cause. So actual cause, also called causation in fact, means that a person is not liable unless actual cause can be proven. We have to show that the negligent act was the actual thing that caused the injury. The legal terminology is often just called but for, meaning but for the negligence, the person would not have been harmed. The next is proximate cause. This is the idea that if there's a chain of events, let's assume some long chain of events, there's a point somewhere along a chain of events caused by a negligent party, after which the party is no longer legally responsible for the consequences of his or her actions. And key in this analysis will be Was the outcome reasonably foreseeable at the time? So, an example here could be, I'm going to give a ridiculous example, and we can try to see somewhere along a chain of events where would negligence not apply anymore. So let's say I'm driving in my car and I'm texting on my phone, not paying attention to the road. So as a result, I run up on the sidewalk and I hit an electric pole. So this causes the pole to fall down. So now there's electric wires on the street. And somebody comes by, not seeing those wires, they trip on the wires and they suffer an electric shock. And while somebody goes over to try to tend to the person who suffered a shock, let's say lightning strikes them. And the person that was struck by lightning sues me, saying that but for my negligent act of texting while I was driving, they wouldn't have struck by lightning. Okay, we have a legitimate question here as to whether or not my negligent act is the proximate cause of somebody being struck by lightning. And the court's going to look at that and try to analyze, well, was that outcome reasonably foreseeable at the time? Well, maybe or maybe not. Probably not. So a case to give an example of causation is James versus Mao Media Incorporated. This happened in federal court, the 6th District. We have a very unfortunate case where a young man has been playing a lot of violent video games, watching a lot of violent movies and other media. And due to a variety of factors, goes into his school and shoots some of his classmates, killing through and wounding many others. The parents of the children who were killed sue Meow Media, claiming that the consumption of this violent media, whether it be video games, movies, etc., were the cause of their children's death. So the court had to consider whether or not a child who plays violent video games or watches violent movies or TV shows, if liability is going to attach to a company that creates that content, if a person watches it and decides to hurt other people. And in this case, the court decided no. They couldn't establish that the consumption of that media was the proximate cause of this child choosing to shoot some of his classmates. They reasoned that there are, most people who consume that type of media don't engage in this type of behavior. And there were a lot of other factors at play, including a lot of a history of mental illness on the part of Carneal, who is the kid who did the shooting. So it wasn't enough evidence there to show that the producers of this type of media are going to have liability in a case of these types of shootings. Unfortunately, we have not seen the end of these kinds of things happening. Even though everybody's in lockdown right now, eventually we're all going to go back to normal life, and we might see another shooting, and somebody else might try to sue another media company. So for right now, it doesn't appear that the media companies are going to have liability. Things could change, but we'll just have to wait and see. Next, let's look at some special negligence doctrines. We'll look at professional malpractice, negligent infliction of emotional stress, negligence per se, res ipsa loquitur, gross negligence, attractive nuisance, and good Samaritan laws. Getting started, professional malpractice is the liability of a professional who breaches his or her duty of ordinary care. This is also known as the breach of reasonable professional standard. So, obviously, if you know anybody who's a doctor, or if you just have a conversation with your doctor and talk to them about how much their malpractice insurance costs, it'll be pretty shocking, the amount of money it costs. Just because, especially if we're talking about a medical professional, the chance for something going wrong is pretty significant, and the cost is also very, very significant. So if a doctor is performing surgery and they breach their duty of care by not following procedure or not following best practice, this kind of thing that can lead to a malpractice lawsuit and potentially very high amounts of money. Negligent infliction of emotional distress. So we talked about intentional infliction of emotional distress. There's also a theory called negligent infliction of emotional distress, saying it permits a person to recover for emotional distress caused by the defendant's negligent conduct. So even though I didn't intend to cause somebody a lot of emotional distress, if I negligently do something, I'm not, I don't even think about it causing emotional distress. But if it does, they could at least try to sue me. And it would be up to a court to decide whether or not I breached some duty of care in that situation. Negligence per se is a special situation where there is a law. There's either a state law, some local ordinance, or some kind of statute on the books. And if I violate that statute, then I'm automatically assumed to have been negligent. I have breached the duty of care by violating that statute. So it just makes it a lot easier if I get sued for that later on. Res ipsa loquitur is a Latin phrase that means the thing speaks for itself. So here, the defendant had exclusive control of the situation that caused the plaintiff's injury. An injury would not have ordinarily occurred but for someone's negligence. We see that but for terminology again. So an example here could be if I go in for surgery and then coming out of surgery, I start to experience problems. And upon x-ray, they discover that somebody left some type of medical device, called a sponge or something else, inside of my body. Now, it doesn't really make sense that that medical sponge could have gotten inside of my body in any other way than the surgery that I just went through. So it seems to speak for itself that the people performing the surgery were the ones that were negligent. Now, maybe there's some outside chance that I could have put it there myself. But based on the facts at hand, it just doesn't make much sense for anything else to be the explanation. Gross negligence means that a person is liable for harm that is caused by his or her own willful misconduct or reckless behavior. The key word here being willful or reckless. This raises the bar, saying not only did somebody breach a duty of care, but they either did it willfully or recklessly, not taking into consideration the safety of other people around them. And this opens the door for punitive damages, which really sort of takes a cap off the amount of money I might be able to get by getting those punitive damages, which are designed to punish. So that's why we call it a special negligence doctrine, is if we can find that willful or reckless behavior, then it really opens up a new avenue for more damages. The attractive nuisance doctrine is a tort rule that imposes liability on a landowner when children are attracted to the landowner's property by an attractive nuisance and are injured on the property. So, common examples being swimming pools or trampolines. These are things that kids are known to really like, and there's a high probability that a kid will, without permission, come onto my property and try to use that pool or trampoline. So as a property owner, I have the duty to try to fence those in or take some reasonable steps to try to prevent kids from coming onto my property, using this attractive nuisance, whatever it is, and getting harmed. So this is going to be something that if I have things like this in my yard or on my property somewhere, I really need to take or have a conversation with my insurance company to make sure that I'm taking the reasonable steps necessary to cover me if somebody is injured on my property and then tries to sue me later on for negligence. So a case example for gross negligence is Alio versus SLB Toys USA. SLB is the parent company of Toys R Us. So Toys R Us has imported a pool slide from China, a manufacturer in China. The slide was inflatable, and it was meant to be put beside an above-ground pool, inflated, and then people could slide down it into the pool. What Toys R Us didn't do was make sure that the slide had been tested to meet American safety standards. So one day, somebody was using the slide, and as they were going down the slide, the bottom part of the slide collapsed. So rather than sliding into the pool, the person slid head first into the side of the pool, killing them. The family sued Toys R Us, saying that they were grossly negligent. At trial, a jury awarded Alio $2.6 million in compensatory damages and an additional $18 million in punitive damages, and Toys R Us appealed. So what the court had to consider was Toys R Us negligent act in not getting the safety testing done, was that enough to count as gross negligence to justify the award of punitive damages? And here's what the court said. Gross negligence is substantially and appreciably higher in magnitude than ordinary negligence. The element of culpability which characterizes all negligence magnified to a high degree. The judge instructed the jury it was deemed admitted that the slide was not tested or certified prior to being imported and sold. On this evidence, the jury could have determined that Toys R Us's conduct evinced want of even scant care as to the safety of its customers. We conclude that the circumstances of this case exhibit a substantially high degree of reprehensibility. Accordingly, the evidence was sufficient to support the jury's finding of gross negligence. So on appeal, the appellate court affirmed the lower court's ruling, and Toys R Us is on the hook for this $18 million in punitive damages on top of the $2.64 million for compensatory damages. So that's a good example of how being grossly negligent can really raise the stakes in a lawsuit. Another special negligence doctrine is Good Samaritan laws. These laws are designed to protect medical professionals who stop and render emergency first aid. So prior to these laws being in place, if, let's say, I'm a nurse and I'm driving down the road and I see somebody on the side of the road in trouble, and me being a nurse, I care about people, I stop to try to help. But in trying to help them, they might even get hurt more. This can be common when administering CPR. And then the person that I stopped to try to help sues me later on for injuring them. That doesn't really seem fair. Maybe it's not right. Maybe it is. Depends on your view. But what this would lead to is doctors and nurses and other healthcare professionals, if they're driving down the road and see somebody in trouble, they won't stop anymore because they're afraid of being sued. So we pass these Good Samaritan laws to try to give them some protection. So it relieves them from liability for ordinary negligence. It doesn't give relief for gross negligence or intentional or reckless conduct. But as long as they're acting reasonably, then they can be protected. Laypersons who are not trained in CPR are not covered in many states. However, they are in North Carolina. In North Carolina, we also have an additional law for drug overdose reports. Now, this is very limited in scope, but the intent behind it was that if we have two people who are involved in doing some type of drug and one person overdoses, the person who's actually conscious might be afraid to call law enforcement because they're afraid of getting in trouble themselves. So we passed this law giving a limited amount of protection for somebody who calls to report an overdose, saying that they have some limited amount of immunity for additional drug charges later on if they're acting to try to save a person's life. It's not absolute immunity. You should be pretty familiar with the law if you ever put yourself in circumstances where this might be a real thing. The best bet is just to not get yourself in those circumstances in the first place. Now let's look at some defenses. So somebody sues me for negligence, and I'm going to try to figure out how I can defend myself. One defense is a superseding or intervening event. So some event happened in between a negligent act and some kind of injury. Something that I could not have foreseen, something for which I was not responsible, and that superseding or intervening event was actually the thing that caused the harm. An example of this, as ridiculous as it might sound, is, let's say that I'm walking down the street, not paying attention to where I'm going, and me not paying attention to where I'm going causes me to trip another person and they fall down. They bang their head and they're unconscious. So while we're trying to tend to this unconscious person to get them some medical care, a plane falls out of the sky, lands on the person, and they die. So their family sues me for causing them to trip, which caused them to be where the plane landed, which caused their death. The plane will probably be considered a superseding or intervening event, something that I was not responsible for, something that I could not have foreseen, and something that's going to defend me against a wrongful death claim. Another defense is assumption of the risk. This is the idea that people engage in risky activities a lot of the time. They know about the risk. They voluntarily choose to participate in the activity anyway. So if I can show that a person knew about the risk and chose to voluntarily participate anyway, then I can probably use the defense of assumption of the risk. This is why anytime I do anything even remotely dangerous, even if I go roller skating or skydiving, bungee jumping, snow skiing, anything, I'm probably going to have to sign a waiver where I sign my name on a document saying that I am aware that there are significant risks of injury here and I choose to participate in this activity anyway. And that will be, they'll show that waiver in court later on if something was to happen and say this person did know about the risk, they did choose to participate anyway, so they assumed that risk and that would release the company of liability. A case to illustrate assumption of the risk is Grady versus Green Acres. This involved an 18-year-old male who went snow tubing. In the parking lot of the snow tubing facility, there was a sign saying that people, just making people aware that there are significant risks associated with snow tubing and people can be injured. The lift ticket that they had to buy also had language to the effect of there are significant risks involved and that people are voluntarily participating. Grady was tubing down a hill face first and ran into a person who was walking at the time, suffering some injuries, and he sued Green Acres, the snow tubing facility, for negligence. The Green Acres obviously brought forth the language of the sign and the lift ticket, showing that the participants were warned of the dangers. They were given the option not to participate in the activity if they don't want to, and that everybody who continued to tube was doing so voluntarily. So the court ruled that Grady had assumed that risk and that Green Acres was not liable. A couple other defenses are contributory negligence and comparative negligence. So whichever state you live in is going to be one or the other of these. In North Carolina, we still use contributory negligence, which is maybe a little bit older of a doctrine. It's a little bit more protective of businesses. You might view that as being a good or bad thing, depending on your perspective. But the idea here is that a plaintiff who is partly at fault for his or her own injuries cannot recover against a negligent defendant. So even if a company was, or another person who was negligent, if I'm at least partly at fault for my own injury, then I cannot recover. So even if there was a dangerous condition, let's say a wet floor or a hole in the sidewalk or something that would otherwise be considered dangerous and perhaps negligent. Let's say if I'm walking head down, texting, not paying attention to where I'm going, a court could find that I'm partly at fault for my own injury, not being aware of my surroundings, and not allow me to recover anything at all. To contrast that, we have the comparative negligence doctrine, which means that we look at the who was how much at fault. So we assign percentages. This person was 50% at fault, the other person was 50 or 60-40, 70-30, whatever it is. And I would be awarded damages according to my percent of being at fault in that scenario. So if I suffered $100,000 in damages, but I was ruled to be 50% at fault, maybe I get half of that award. Or if I was only 30%, then I would get 70%. And then some states have a rule called partial comparative negligence, where I have to be less than 50% at fault for my own injuries before I can get anything. So if I'm more than 50% negligent, contributing to my own injuries, then I can't recover anything. Last, we look at the doctrine of strict liability. This is establishing liability without showing that anybody was at fault in any way. There are certain activities that can place the public at risk of injury, even if reasonable care is taken. This is generally applied to activities that are considered to be inherently dangerous. Examples: defective products. Now, in North Carolina, we don't attach strict liability, or we don't apply strict liability to defective products, especially if we're talking about a retailer who wasn't aware of the defect. But in a lot of states, strict liability does apply there. However, if I'm storing or using explosives, if I'm using or transporting certain kinds of dangerous chemicals, if I'm keeping dangerous animals, or if I'm performing controlled burns, even if I take all the necessary reasonable precautions, if something was to happen, then I'll probably be found liable anyway. I don't know about you guys, but during the COVID crisis, I found myself at home watching a lot of Netflix, and I did watch Tiger King, which is phenomenal if you get the chance to watch it. So let's assume I'm keeping a bunch of very dangerous animals like tigers and lions. And even if I have fencing around there that's designed to keep them in, if one of those animals gets out and harms somebody, even if I was not at fault in any way, even if it was some freak accident, I'm still going to be held liable under the doctrine of strict liability. That's it for this lesson. Have a great day.